Good morning.
Yep. Thank you.
Mr. Scott,
Yeah,
we're here today for your revocation hearing. And I have your attorney here, so we're going to get started, okay?
all right.
Good
Can you
morning.
see
I can see you. Yep. Good morning. I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Scott Arden, number 397159. Today is January 15, 2025. This hearing is being conducted via video at the BOPP Central Office and the Cheshire Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Inmate Arden Scott 397-159.
Do you have counsel here today? Please identify yourself for the record.
Good morning, Public Defender Robert Famigletti of the Parole Revocation Unit. Hello, sir.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge to state your appeal is bringing against you. And we'll review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Your important rights today: the right to have an attorney present. You have counsel here. You've received the written notice of charges of violation. Did you receive the written notice? Did you receive the written notice stating why you're here?
Say absconding.
Right, but it's the document with the charges on it that we reviewed, sir. Did you receive that?
Yeah, they read it to me over the phone.
Yes.
Okay.
Yeah. You have a right to view evidence. You have a right to submit evidence supporting your case. At this hearing, right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge. State your appeal is bringing against you. Any information underlying each charge. Charge 1, a release checks and absconder. Your charging officer reported on 12/14/23 at 1:08 a.m. You walked out of the Chase Center halfway house, filling parole-approved residence with 2 Walmart bags without authorization from the halfway house or parole. Staff followed you out of the halfway house and directed you to return to the facility. You refused and continued to leave the physical premises and confined to the facility. The attempts to locate via phone calls went unanswered, not returned. No attempt to locate was conducted as all of your social supports reside in New York. You made no attempts to contact parole or halfway house since leaving on 12/14/23. Whereabouts the community remained unknown. Charge 2 under travel. Your charging officer report on 10/15/24. You're apprehended by Pennsylvania Police Department on 11/15/24. You were extradited back to Connecticut by members of the Parole Fugitive Investigation Unit. You do not have permission to leave the state of Connecticut based on your actions in violation of travel. Charge 3 under travel waiver of extradition. Your charging officer report on 10/29/24. Members of the Parole Fugitive Investigation Unit arrived at the Erie County Prison to extradite you back to Connecticut. You refused to comply with the extradition process, telling the officers you were not going anywhere with them. You signed conditions stating you will not leave the state of Connecticut and would abide by your signed conditions of waiver of extradition as set out in your parole application. Based on your actions, you're in violation of condition travel waiver extradition. Charge 4 additional conditions halfway house placement. Your charging officer reported at 7/8/23. Immediately upon admission to Chase Center halfway house, you were non-compliant with prescription medication from 7/28/23 to 8/11/23. You refused to take medication for your physical mental health as prescribed. On 8/16/23 at 1:21 p.m., you left the facility on a community pass to the Western Union Office of Waterbury. You're scheduled to return to the facility by 2:45 p.m., but not return until 4:45 p.m. When asked why you're late, you stated, "Don't you come to work late sometimes?" On 8/17/23, approximately 8:05 during morning house count. You were not in your assigned room. Number 28 were not accounted for. Staff paid you the front desk by reading that report as directed. Staff searched the facility and found you in room 32's bathroom, another DOC resident. On 9/18/23 at 12:08 p.m., you walked out of the front door of the Chase Center halfway house without authorization from the halfway house or parole. Prior to leaving, you stated you had to pass the Walmart. However, staff verified that there was not a pass. The halfway house PD informed you that your pass was denied because you went to Walmart the previous week and had requested the pass last minute. You returned to halfway house 2:32 p.m. On 9/20/23, during a medication audit, determined compliance, staff noticed you refused to take your medication as described. Your actions violated halfway house agreement. On 9/26/23, during a medication audit, determined compliance, staff noticed you refused to take your medication as prescribed. On 9/27/23, during medication audit, determined compliance, staff noticed you refused to take your medication as prescribed. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand and custody order; B, parole violation report; C, signed PCS conditions; D, halfway house agreement; E, community solutions incident reports; F, community solutions incident disciplinary reports; F, offender misconducts; H, parole rights; I, parole violation notice; J, ticketed itinerary for 10/29/24, extradition attempt; K is refusal to sign application of parole with PO Donato on 2/25/19. Did you receive the notice of parole violation report, and those other items that I just stated? And did you review it?
Yes, we have.
Okay. And council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
We don't have witnesses. I will put on the record the addendum I received did state on January 26, 2024, the BOPP did issue an absconder warrant for the offender. So now it is defense's opportunity if you'd like to speak at this time.
As to the preponderance of evidence standard, only comment as to his refusing extradition. I don't think we have sufficient evidence there as to the why, the how, the when he exercised his right to refuse the extradition. And as to the halfway house placement, those allegations are almost a year and a half old. Thank you for your time and consideration.
Thank you. So what I'm going to do next is I'm going to announce my findings after reviewing evidence submitted by the state as well as listening to testimony. On charge 1, I do find you violated condition absconder based on a warrant being issued by the BOPP and evidence that was provided in support of the charge, which is exhibits B, C, and E. On charge 2, I find you violated condition travel based on evidence that was provided B, C, and J. On charge 3, condition travel waiver of extradition, I do find you violated that condition based on evidence provided B, C, and J. And on charge 4, I find that you violated condition halfway house placement based on the evidence that was provided, which is exhibit C and D, as well as G and E on parts 1, 2, 4 through 7. No finding on part 3, which is dated 8/17/23, as there's insufficient evidence to support the charge on that date. That includes the fact-finding portion of this hearing. Before I make recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to at this time.
Thank you. My client is 35 years of age. He receives support from his mother, father, and 3 sisters. The majority of his contacts and support are outside the state of Connecticut. While in Connecticut, he worked in the shelter. He formed a resume. He got his identifications. He was working at the shelter in a custodial and maintenance capacity. I'm not sure where he wishes to be placed in a halfway house in Connecticut, sir. You did not specify with my social worker. When released, where in Connecticut would you like to be housed?
I want to go back to the same halfway house I was at. That's the only halfway house I stood there for 6 months.
Where is that?
Oh, Chase.
What town?
And Waterbury.
Waterbury. Okay, thank you. He wishes to return to obtain his GED. He wishes to obtain a security license, and he was working towards it when he was in the Bronx. He wishes to be released as soon as possible. We're basically looking at an absconder. Many of those violations are minor, having to do with not taking medicine some year and a half ago. I think the recommendation of parole officer is excessive, 18 months to 2 years. Will essentially be warehousing him. My client does suffer from bipolar disorder. He can be impulsive at times, and I think when he's medicated, he makes better decisions. Thank you for your time and consideration.
I also
you.
have my certificate. I also have my certificate for I took classes for Narcan. I also want to put that on record. I have my Narcan certificate license. I achieved that. Also, like you said, I achieved my resume. I felt well with my identification card. I was helping, voluntarily working. I was in the shelter. There's a lot I was going on, and the only problem was just that the location for me not receiving my ID and me was being in this residence where I'm not from. So it was just a little difficult for me. But besides that, I was being successful in society. I was showing you guys that I can work in society on my own without having to be always monitored or supervised. You know, I actually accomplished in society on my own. And regardless of what you're going to give me today, I want to say that I'm proud of myself for accomplishing these things that I did on myself in society. That's what I had to say.
Sir, are you willing? You're going to be on parole, I think, until 2032, correct?
No,
So,
that's incorrect.
When do you have
2029.
What's that?
2029. That's 10 years.
29?
From 2019.
I
10
was
years.
asking the hearing examiner, actually.
Oh,
When is his parole over? Because our information is 2032.
May 10th, 2032.
Okay.
Is the-
It
is
may
the
have been
end of-
extended because of your absconding, sir.
Every time it
majority of-
absconds.
Majority of the time I was incarcerated. That's what I'm
Okay,
saying.
sir, we're not going to get into an argument here as to when your release date is. We can talk about that another time. Okay, but basically the gist of my questioning was, because you're going to be supervised for some time, you were talking about how well you did when you were independent. Are you willing to work in Connecticut with a parole officer?
I never received one to start with.
But if you were to get one,
I gotta get out first.
I'm just trying to help here, sir, by asking, because you absconded, whether you're willing to work in Connecticut with a parole officer to better yourself.
Do I have an option? That was you
No,
telling
you
me?
don't have an option, frankly. But
All right, then. So that's not even a question to even.
Okay, sir, I was just trying. One
Well, you
second.
do have an option. If you're telling me you're not gonna and you want to stay in there, I can keep you in there. So, I mean,
Right, I don't want to stay here. That is,
I know, sir, I was trying to help you.
That's not one of my options. Staying in jail
Okay,
for
sir.
what?
Okay, I was trying to help you, sir, to see if you
I
were
understand what you're
willing
saying.
and able to work with someone. Thank you.
Yes.
Good.
Yeah.
all right. So I'll be right with you with a recommendation. All right, so I do want to put on the record, Benner was in the community for about 4.5 months before absconding from supervision to a later state. There are 4 prior parole violations for absconding. This is the offender's 5th violation, as well as the offender was found guilty of refusing extradition. There are 5 misconducts that received prior to absconding. 18 months to 2 years is recommended by the field officers. Based on all the information I have, I'm going to recommend that parole be revoked to be reparoled for September 15th of 2026, which is an 18-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, a general no contact with Walmart loss prevention, no contact with co-defendants Tyreek Dennis, Terrence Smith, behavior management program for anger management, and a mental health evaluation and treatment would be necessary. My findings are going to the parole board on January 30th. So the board's going to make the final decision on when and if you should be reparoled. This is just a recommended. Do you understand?
The No, I don't
Sir,
understand.
the max, the
It
maximum.
says 12 months. The
No,
max
sir,
is 12
that's,
months.
sir,
No,
that is an old policy.
So you
that
might
was
as
in
well max me out. Max me out.
Sir,
Max me out.
are you,
Max me out. I
sir,
wouldn't do that. Nah,
Sir.
I want to get maxed out. Max me
Sir.
out.
that is
it's
not a
up to
policy.
the board.
There is no
Nah,
year
max me
policy,
out.
sir.
Max me out. I'm leaving the state if you let me out. Put it like that. Max me out. Put me like that. Max me out. I don't want to deal with your state. Max me out.
Sir,
Max me out.
there is no
Max
longer
me
a
out,
one.
man.
Are you gonna talk over
I'm
me
talking
or?
to her, man. Max me out, man. So when I
Have a
walk
good
out
day,
this
sir.
state, I ain't looking back. Max me out. Max me out.
It's up to the parole board.
I mean, it's up to you. You recommended it. It's up to you. You fucking
It's a
recommended it. What
recommendation.
you talking
That's
about?
not, I'm not the
I
parole
don't
board.
care.
sir.
You can't recommend it. You can't recommend it. Something it's only 12 months. What are you talking
Sir, that's
about?
not
The max
true.
is
It's
12
not
months.
only 12
Yes,
months.
it is.
You're
Check
wrong.
it out. So max me out.
You're
So why
wrong.
you can't
sir.
max me out?
No,
Man,
the
suck my
board
dick.
can't,
Max
the
me out.
board
Man,
likes
suck
to.
my dick. Max me out. Fuck out of here.
All right, so that concludes the hearing.
Yeah. What you talking about, bitch?
Have a good day.
Suck my dick.
Thank you.
Good morning, P.O. Goodman.
Good morning, sir. How are you?
Oh, just call me Rob. Don't call me sir.
Good morning, Rob. How are you? Call me Kim, please.
Okay, Kim. Good morning.
Good morning. Good afternoon.
Good. Well, that was a fiery end.
Yes, we are going up in flames today.
No.
It's just hope there.
Let's hope.
I did call Garner to let them know an updated time, so a CO should be nearby.
Thank you.
They're usually pretty good. I guess I should say Happy New Year. I haven't seen you guys since the new year.
And Happy New Year's.
Hope everybody's holidays were good.
Hope yours was too.
Quiet. I took a staycation.
That's the best thing.
It was nice not to have an alarm clock going off at 6:15 every morning.
We tried to hold it back.
Just take a look up. This is my testimony.
Perfect. We'll be down shortly.
Thank you.
Did he say he'll be right with us? Is that what he's?
He said he'll be down shortly.
Oh, okay.
So they probably have to pull him out of his unit.
Okay.
I don't know what block he's on, so I don't know how close he is to the visiting area.
It's just par for today.
As long as he's coming down, it's all good.
Yeah. We couldn't have something go smoothly today, could we?
Yeah.
I will try not to contribute to your both of your bad days.
No, I think we're good. I think it's all good.
We're in the straightaway now.
Oh, well, that's good.
Yeah.
I just had a quick question. You have an interesting one coming up, I believe, after Mr. Lewis.
No, actually, that's continued.
Oh, okay, good. Then I was
This
going to
is-
say if you would mind if I'd stayed on and watched it because we're so familiar with that case.
Right. Yeah, no, that's been continued. Actually, I need to put that. I do want to put that on the record, which I will do now, just because we're waiting.
Sure.
In regards to the 11:45 hearing for Charles Cornelius, number 296776. This case has been continued to be heard for January 29th, 2025 for the preliminary hearing.
That's it, no doubt. No doubt. That's it. You can go right up in here, they should all be waiting for you, okay?
Thank you. Good morning, Mr.
How
Lewis.
you doing?
Good, how are you?
Hey,
Good morning, Marlin.
morning.
Hello,
we're
Mr.
here.
Lewis.
We're here for your hearing today, so we're gonna get started, okay?
All right.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Lewis Marlin, number 379405. Today is January 15, 2025. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Marlin Lewis, 379-405.
And you have parole officer here today. Please identify yourself for the record.
Parole Officer Kimberly Goodman.
And we have counsel here today. Please identify yourself.
Yes, Public Defender Robert Famagletti of the Parole Revocation Unit. Hello, sir.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure at this time?
No, Your Honor. No, Your Honor.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yeah.
Okay. You have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
Okay, so now review the charge. The state your appeal is bringing against you and the information allowing you charge. So P.O. Goodman, if you could read the charges, you don't have to read number 1 as a no finding was made at the time of the prelim.
Yes, thank you. One moment, please. Okay. Obey all laws. Obedience to the law. On 10/23/24, you made threats to assault Whiting Forensic staff, hospital staff on Unit 6. You entered another patient's room unprovoked and physically assaulted them. While the patient was lying in his bed, you jumped on top of him and punched him in multiple times in the face. You were face and head. You were restrained as you presented an imminent risk. You continued to make threats of assault on staff and you spit on the doctor. You had to be moved to another unit. Your behavior meets the threshold for Connecticut General Statute 53A-60 assault second. On 10/24/24, you became agitated and attempted to assault staff on Unit 4. You threatened to stab staff with a spoon. You had to be restrained. You were combative. You bit the inside of your mouth and spit blood at staff. Your behavior meets the threshold of Connecticut General Statute 53A-181, breach of peace in the second. Based on your behavior, you are in violation of special parole condition number 2, obey all laws. Mental health treatment. On 10/24/24, you were remanded from Whiting Forensic Hospital per the request of Whiting staff for threatening and assaultive behavior. Because of your removal for such behavior, you were unsuccessfully discharged from your mental health treatment program. You are in violation of your conditions of parole, additional condition, mental health treatment.
Thank you. And the state is following exhibits that are pre-marked for identification purposes as Exhibit A, signed parole conditions; B, remand national custody order; C, notice of parole violation, parole rights; D, parole violation report; E, Whiting Forensic Hospital integrated progress notes; F, misconduct report; G, DOC disciplinary report; H, email from Dr. Berger; I, documented conversation between PS Man and Dr. Berger; J, Demas police case incident report; K, email from Lieutenant Driscoll, RE assault; L, assault second description; M, breach of peace second description; N, revocation hearing summaries; O, misconduct report; and P is probate involuntary commitment decree. Did you receive notice of parole violation report, and those other documents I marked? Did you review them, sir?
Yes, we have.
Okay. And council has filed the following exhibit pre-marked for identification purposes. That's Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
You don't have any witnesses. At this time, I'm going to swear in P.O. Goodman as well as Mr. Lewis in case you want to speak.
I'd ask that you not swear in my client because there is a pending assault charge
Okay.
in Middletown Court. And I'd ask that I'm going to advise him today not to make any statements on the record about
Okay.
what may or may not have occurred there. So, sir, I don't want you to make any statements about what did or occur or didn't occur at Whiting because I don't want them to use any of those statements against you, okay?
Okay.
All right. So, P.O. Goodman, please raise your right hand. You solemnly swear, solemnly, sincerely affirm, as the case may be, the evidence shall give, in this case, shall be the truth, the whole truth, nothing but the truth, so help you God, if I penalty of perjury.
I do.
Okay, would you like to say anything right now in regards to the charges?
Just related to, with regards to the charges, Mr. Lewis was placed at Whiting Forensic Institute on a involuntary probate commitment as he was found to be gravely disabled and a danger to himself and other people. And as evidenced by his behavior on said dates, that was actually probably the best decision that the court could have made at the time. This is also the fourth time that Mr. Lewis has been involuntarily committed to either Whiting Forensic Hospital or Connecticut Valley Hospital because he has been a danger to himself or others. And it is accurate that what Attorney Famigletti said, that we have learned that there's a pending matter warrant out of Middletown Court that has yet to be adjudicated. Mr. Lewis has a significant history when being out in the community and in the institution, and it should be of note that the violence that he displays is for secondary gain and has been documented multiple times that when he has committed those assaults, he has not been found to be paranoid, delusional, hallucinating, or disorganized.
Thank you.
Thank you.
Okay, turn over to counsel if you'd like to say in regards to the charge.
Yes, as to the charges, obviously a no finding was made as to charge 1. I think a no finding should also be made as to charge 3, because the only reason he was discharged from treatment was because of the remand. It wasn't him not cooperating with treatment. And so I don't believe there was any intent, no action of his own ended that treatment. It was because there was an order remanding him. I have no comment as to charge 2, other than I don't think anyone can jump inside anybody's head, whether you be a psychiatrist, a psychopharmacologist, any type of doctor, trying to estimate or try to understand what motivates someone who has a compromised brain chemistry. There's no such thing as a perfect brain. We all suffer from different chemistry in our brains that causes us to act or not act in certain ways, shape, or form, and trying to assume or judge that someone's mind wasn't compromised when they were acting, when they do carry a diagnosis and they have been involuntarily committed because of their grave disability. I think it's a little presumptuous to assume when someone is acting under color of brain chemistry that's disturbed or not. Thank you.
Excuse me, guys. I'm just wondering if it's going to be past 12 because if so, I'm going to have to put them on my count.
It cut close to it.
Okay, thank you.
Yes. Okay, thank you. So what I'm gonna do next, is I'm gonna announce my findings, based on evidence and testimony that I have reviewed. So in regards, like we had previously stated, charge 1 is not taken into consideration, no finding was made at the time of the prelim. On charge 2, I do find you violate condition obedience to the law based on evidence that was provided in support of the charge, which is exhibits A, E, J, K, L, part 1 and A, E, M, part 2. Regarding charge 3, I do find you violated additional condition mental health treatment based on evidence that was provided, exhibits E, H, I, and P. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, council will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So P.O. Goodman, would you like to say anything at this time?
Yeah, this is the 5th time that Marlin has violated since his release to the community. He's had one escape, which was a Class E felony that he was convicted of while he was at a halfway house. He had one absconding, he had one technical, this would be the 2nd technical, and he had another criminal charge for very similar behavior at Connecticut Valley Hospital. We have attempted to work with Mr. Lewis since 2019, and he continues to be uncooperative with his abiding by his parole conditions of parole. Again, as I stated earlier, a court on 4 separate occasions has found him to be a danger to others, and he has presented that way in the community and in least restricted, controlled environment, and he continues to utilize violence for secondary gain. I don't know how many times a court needs to deem him gravely disabled and a danger to himself or others before we stop kind of putting him back in the community and creating other victims. We have created at this point now, if I'm not mistaken, 1, 2, 3, and potentially with a pending case, 4 victims of Mr. Lewis's violence. And we are recommending a full revocation to be reviewed as policy. I believe it's annually unless that's changed. He would be found gravely disabled and a danger to others again if we released, and at that point would have to be placed back at either Whiting or CVH. I'm not sure how many times we need to do that or how many times he needs to prove to the parole board that he's not a good candidate for parole, even though special parole was ordered at the time of his sentencing. I do want to put on the record that at the time of his preliminary hearing, and it is in the prelim summary documented on multiple occasions, that he claimed that the reason for his behavior is that he was allergic to Depakote. Nowhere in his medical record, and I've checked the EHR with the Department of Corrections and with DEMIS, is there an allergy to Depakote. In fact, his only allergy listed, which is a mild one, is to risperidone. So I want to make sure that that's on the record, that, you know, you can either you're mentally ill or you're not. Not all people who are mentally ill and diagnosed with a mental illness and or meet a hospital level of care assault people on a regular basis for secondary gain. And it was documented in the reports that Mr. Lewis did not want to go to a step-down unit from Whiting at Dutcher and wanted to be released to the community, and thought that if he committed these acts that, you know, he would get his way. And I'm sorry to say that it didn't work. And it didn't work the 4 other times that he's been violated as well.
So if when he comes back out, would he be going back to Whiting or CVH?
Potentially, yes, if he's found to be gravely disabled and a danger to himself or other people. I would say at this point, the answer to that question would be yes. However, I'm not sure how willing or unwilling Whiting and CVH are going to be able to work, because in the past 6 years, he's created several victims, including staff over there. It's not just other people who are struggling and who are mentally ill. He takes advantage of, he assaults the staff, but he takes advantage of people who are weaker than he is. So, you know, he does not have any place to go.
That's not
That's
true.
been
but-
presented to us. I mean, I did get the defense's evidence yesterday, and it just says that he's amenable to everything. So I really don't know what that means, because in 6 years, he hasn't been amenable to much.
Okay.
Maybe heard now?
And the other, you
Now
know,
that I have 1
another
minute,
thing I
now
want
that
to
I
say
have 1
too.
minute.
Yep,
Wait,
yep. The other thing I want to say too is we don't know what's going to happen with the outcome of this new criminal charge.
That's
he could-
irrelevant to today's proceeding.
But you put it on the record, so we still
But
don't
it's
know
still-
what's
no, no,
going to
it's
happen with
irrelevant
it.
as to the decision today.
Okay.
Can I be heard now in this last minute that we have?
you can, yeah, well, it's now going to be your defense's turn, so if you'd like to
Thank you.
speak. Yep.
No, take all the time you want. They can wait for the count. That's
Yeah,
fine.
you're not we're not sending him back until we're done, so you have
Thank
time. Yeah.
Okay, so my client doesn't have a choice here today. He's either going to go to Whiting Forensic because he's been committed there by the probate court. And I spoke with probate court in North Fairfield. So he's the subject of an involuntary commitment until that's changed. So he's either going to be at Whiting Forensic or he's going to be incarcerated. And there's no question he's gravely disabled. So our question today is how much time he's going to serve in jail. Are we going to warehouse him in jail? Or are we going to send him back to the treatment, which he just so desperately needs? What happened on that day is going to be decided in court as to whether or not he's going to be punished. And there's no information that he's not going to be able to go back to Whiting Forensic. He's under an order. That's speculation. So our decision today is what the sanction should be for this conduct. That's our decision today. And I don't think revoking his parole is the answer. My client is 34 years of age. He's involuntarily committed due to his mental illness. He's going to be a danger to self or others, and they knew he was a danger to self or others when they committed him to Whiting. He's going to be a danger to self or others if he's in Whiting, and he's going to be a danger to self or others if he's incarcerated. It's as a result of his mental illness. It's as a result of his compromised brain chemistry. This is like diabetes. This is like a heart condition. My client was born. He's been on SSI disability since he was 16 years of age. He needs management. He needs appropriate treatment. I think it's noteworthy in the Department of Mental Health and Addiction Services Public Safety Division report that both the clients are at end of sentence and have a legal status of probate commitment psychiatric. That's both parties to this argument. The patient did not wish to pursue charges due to not wanting to be labeled a snitch. This is the end of the report from the police that were in charge of managing the situation. The Demas Police Department will not be pursuing criminal charges in this matter. This incident will be handled clinically. It's only afterwards that the warrant was submitted. This type of conduct, unfortunately or fortunately, occurs while someone with a mental illness is in a setting such as Whiting Forensic. The answer is not to take someone with a mental illness and revoke their parole because they are symptomatic. Any conclusion that he was not acting through the filter of his mental illness is preposterous. His personality, his actions, his sense of self-being, his decision-making process is all filtered through his compromised brain chemistry. There's no separating when he's acting one way and when he's acting another way. They're all actions. His intent or lack of intent or acting or inacting is all tied to his decision-making process, which we've known is gravely disabled and compromised. I think if we throw away the key today and send him in jail, that is the wrong answer. Thank you very much.
May
Thank you.
may I just clarify on the record
Yeah.
that the charges that are currently pending have nothing to do with what was charged on this PVR. It's a completely separate incident and not related to any of the charges. It's a whole nother charge. And it's not charged in this current violation.
Which further proves myself that this is conduct related to his mental illness. You cannot separate his actions and say this is intentional and say, no, this isn't intentional. This is all colored by his mental illness. And persons with mental illness, as decided by the probate court in this set of circumstances, has placed him at Whiting Forensic. We don't just throw away the key and totally revoke someone's parole because they're difficult or because they're assaultive.
Well, this behavior only happens in the context of when he's released from custody. It doesn't happen if you review,
In the
if you
past,
review his
we don't
DOC
know that.
history. It doesn't happen. It doesn't occur within the Department of Corrections. It occurs upon release.
In the past, there's no reason to take away his freedom any further than it's already been taken away. Thank you.
My understanding is also the facility will have to reapply for another commitment
Fine.
because
Let
that
them reapply.
commitment became vacated. So there's no guarantee he can go to Whiting.
People having to do more work, people having to do their
that's fine.
job.
We
I'm
can
just
do that.
saying, should not be an impediment to my client getting the treatment that he needs. Thank you.
All right, so I've noted what both the state as well as defense has stated. So I'll be right with you with my recommendation.
Thank you.
I will put on the record that the offender was on parole for about 2.5 months before he was returned to custody for this violation. He does have 3 prior violations, a criminal misconduct and technical, as was previously stated on the record. So this is his 4th parole violation. He does have a history of violence and absconding, as well as which includes assaultive behavior. And I just want to put on the record too, as well, that I am noting that there are currently pending charges that are not related to this parole violation. So based on this information that I have and on testimony provided today, as well as the interest of the offender, I'm going to recommend that parole be revoked and that the offender be reparoled for January 2nd of 2026, which is an approximate 1 year and 2-month period confinement as a sanction, leaving the offender with 1 year on special parole supervision. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with victim GHOBMB, behavior management program for anger management, general no contact with 263 Laura Street, New Britain, Connecticut, and mental health treatment and medication compliance. My findings are to go to the parole board January 30th. So the board's going to review this and they're going to make the final decision on what happens. The board can agree with my sanction, they can lessen that sanction, or they can revoke all the special parole as well. So it will be up to the parole board. Mr. Lewis, you'll know on January 30th what the parole board's decision is, and if they're going to reparole you, and if they're going to agree with my date or list a different date. Do you understand that?
So what's going on when I go to probate court?
So I'll explain it to you. Nothing's going on at probate court right now. I spoke to probate court. You're not represented in probate court. You don't have a conservator. That lapsed. What happened today is that the hearing examiner recommended a 14-month sanction. So that is a release date of next January, the beginning of next year. So just over a year, but the time you've done has already counted.
Okay.
That's not a final decision. That final decision will be made by the board, sir, on January 30th. So at the end of this month, you'll find out what your release date is, and you can call me and tell me, and I'll call you and tell you as well. You'll get a letter you'll also get a letter in the mail, sir, from the board telling you when your release date is, okay?
All right.
All
Thank
right?
you. Thank
You're
you.
welcome. Good
All
luck,
right, you're all
sir.
set for today.
Thank
Bye,
you.
Marlin.
Thank you.
January,
Thank you, Field.
You said January what?
January 30th is the decision. And
Okay,
the release, okay, sir?
all right.
Okay, thank you, guys.
Thank you, guys.
Thank
Have a
you,
good day.
Ken.
Bye, Rob.
Bye.